Imagine a law designed to shake up the pharmacy industry. But is it truly fair or just a power grab? Let's dive into the controversial Arkansas Act 624 and the recent court ruling that has everyone talking. But here's where it gets controversial. The law aims to prevent pharmacy benefit managers, PBMs, from owning or operating pharmacies. But is it really in the best interest of the public, or is it just a way to stifle competition? Let's break it down. In late July, a federal district court judge made a significant decision in the ongoing legal battle between CVS, Express Scripts, the Pharmaceutical Care Management Association, PCMA, and the state of Arkansas. The judge granted a preliminary injunction, effectively putting Arkansas Act 624 on hold until the case is finally resolved. This act, set to take effect on January 1, 2026, prohibits PBMs from owning or operating pharmacies within the state. But why the sudden halt? The plaintiffs argued that the act is unconstitutional and violates several key provisions, including the Commerce Clause and the Supremacy Clause. And this is the part most people miss. The judge's decision hinged on the likelihood of the plaintiffs succeeding on the merits of their arguments. The judge's 17-page opinion delved into the complexities of the case, highlighting the extraordinary nature of a preliminary injunction. To grant such an injunction, the judge had to consider four critical factors: the likelihood of success on the merits, the potential for irreparable harm, the balance of harms, and the public interest. The plaintiffs presented a multitude of arguments, but the judge focused on two key claims that seemed to carry the most weight. The first involved the Commerce Clause, and the second was a Supremacy Clause claim related to TRICARE preemption. The Commerce Clause, a fundamental principle. The Commerce Clause is a cornerstone of federal law, ensuring free trade among the states. The Dormant Commerce Clause, in particular, prevents states from unfairly discriminating against interstate commerce. The judge noted that Arkansas Act 624 appears to discriminate against out-of-state companies, specifically targeting the business tactics of the plaintiffs. The act's stated purpose is to eliminate these tactics, which the state claims have driven locally operated pharmacies out of business. But is this truly a matter of fairness, or is it a thinly veiled attempt to protect local interests at the expense of national competition? The Supremacy Clause. Federal law trumps state law. The Supremacy Clause ensures that federal law takes precedence over state law, preventing conflicts and confusion. The plaintiffs argued that Arkansas Act 624 interferes with three federal laws: TRICARE, the Employee Retirement Income Security Act, ERISA, and Medicare. While the judge rejected the ERISA and Medicare arguments, he agreed that the act is explicitly and impliedly preempted by TRICARE. TRICARE contains an express preemption clause that overrides any state laws inconsistent with its program. This means that Arkansas Act 624, as it stands, cannot coexist with federal law. The judge's decision to grant the preliminary injunction means that Arkansas Act 624 is currently blocked from taking effect. But this is far from the end of the story. The case will continue to unfold, and the final disposition could have significant implications for the pharmacy industry and the balance of power between state and federal law. So, what do you think? Is Arkansas Act 624 a necessary protection for local pharmacies, or is it an overreach that stifles competition and violates federal law? The debate is far from settled, and your thoughts could be the spark that ignites a deeper discussion. Don't be shy. Share your opinions in the comments below.